This is my third conversation with today's guest, and that alone should tell you something. Because when you find someone who not only understands the system, but can actually explain it in a way that makes it usable, you keep that conversation going. Benjamin Pomerance serves as Deputy Counsel for the New York State Department of Veterans Services, a cabinet-level agency created in 2023 to serve as the state of New York's primary advocacy and assistance office for veterans, service members, and their families. In his role, he wears multiple hats. He supervises the department's appellate unit, leads training initiatives across the state, serves as legislative liaison, and helps shape programming that directly impacts how veterans access benefits and services. And that last piece matters, because access is where this system either works or doesn't. Benjamin's background is deeply rooted in advocacy and law. He graduated at the top of his class from Albany Law School, where he also founded the school's Veterans Rights Pro Bono Project, work that earned him the New York State Bar Association's President's Pro Bono Service Award. He has gone on to build a career that blends legal scholarship, direct advocacy, and systemic reform, publishing extensively on issues ranging from veterans law and treatment courts to broader questions of justice and access. But what sets him apart and why this conversation matters is not just what he studied, it's what he's been working on right now. In the last year alone, the New York State Department of Veterans Services has been actively involved in expanding access to benefits, strengthening representation for veterans navigating claims and appeals, and building out training pipelines for the advocates who stand between veterans and the system itself. Benjamin has been directly involved in efforts to expand eligibility for New York's Veterans Tuition Award, broadening access so more veterans, whether through combat service or extended active duty, can qualify for educational support beginning in 2025. He has also played a role in statewide initiatives focused on increasing access to trained veteran service officers, including partnerships with institutions like Albany Law School and the New York Health Foundation, because, as he has made clear in both his work and his writing, without skilled representation, veterans are significantly less likely to obtain the benefits they've earned. And more recently, his work has intersected with state-level conversations on mental health access, including participation in hearings examining how to improve outreach and support for veterans across New York. That through line, access, representation, and outcomes, is where his work lives. And it's also where this conversation expands beyond New York, because what's happening at the state level, especially in a system like New York's, is increasingly filling gaps that exist at the federal level. The VA is a national system, but access to that system is not equal. It depends on awareness, it depends on guidance, and very often, it depends on whether a veteran has someone who knows how to navigate it. What New York is building through training, outreach, and advocacy is not replacing the VA. It's making the VA accessible. And that distinction matters, because one of the most consistent breakdowns we see nationally isn't just in the policy, it's in the execution. Benefits exist, programs exist, but without knowledgeable intermediaries, without structure at the state and community level, too many veterans never reach them. So when we talk about what's happening in New York, we're not just talking about a state model. We're talking about a case study in what happens when you intentionally close the gap between a federal system and the people it was designed to serve. Because the reality is, the system doesn't fail only because of a bad policy. It fails when people can't navigate it. And that's where this conversation is going. Not just about what benefits exist, but who actually gets them, why they don't, and what it takes to close that gap. Because if you've listened to our prior conversations between Ben and I, you already know. Benjamin doesn't stay at the surface. He goes to structure, to friction points, to what's actually breaking down and why. And today, we're continuing that. I'm Jen Wagman, and this is Vetted. Benjamin, how are you? It's so good to see you. It's been a long time. This has been a long break for Vetted, and I'm thrilled to have you back on as one of the first guests in 2026. My favorite partner in crime, welcome back.
It is wonderful to be back, Jen. Thank you so much. Thank you for keeping the podcast rolling so successfully, and looking forward to another great conversation with you this afternoon.
Oh, this will, I hope, be the first of many. We have a lot to talk about. So many things have been going on and happening in the legal world of veterans benefits. And I don't know about you, but my head has been on the verge of exploding more than once over the course of the last few months. And I think we should just sort of dive in and start talking about some of the things that have been affecting our veterans and military families. They will become, and how this is rolling.
Yeah,
You have
absolutely.
anything in particular you want to start with, or?
Well, I mean, the one that I recall lighting up my email inbox the most was when the Secretary of the VA, Secretary Doug Collins, proposed a interim final rule, which was really not much of a proposal. It was more of a mandate that ultimately he wound up having to rescind, and the traffic around that was fascinating to follow. Right?
It sure was. I couldn't believe it. When that first came through, I went, no, no. And that was
I had the same
just a
reaction.
couple hours. Well, that was an interesting morning and then afternoon and a couple days following. But, we could talk about the logic of it and
Yeah,
whether or not, based on the reactions that we got from all of the communities, I think that was interesting and worth commenting on because it really ignited a grassroots response, both from the veterans and from the veteran service organizations. That was very positive. You haven't seen that much uh, get together response, everybody coordinated and sort of said absolutely not,
not on our
and
watch.
very
Yeah,
very, yeah, which I thought was
and that
really
was the
good. But
feeling, right? Like it was a
mhm.
feeling of this is not going to happen while we are here to say something about it.
Well, so for those who don't know what we're talking about, this rule basically was going to say that it doesn't, you the rating, your compensation will change in that, I'm going to make something up. You're getting 10%. And that's your medicated. It, if you are medicated, it doesn't matter whether or not you are medicated. You're compensated based on your symptoms as if they were untreated. And the
Right.
fact that you're taking medication doesn't change that. You shouldn't have to take medication. That's the
Hmm.
whole point of it.
Exactly.
And
Yeah.
this rule, what came in and said, well, if you're taking medication and that makes you better, then you're better.
Hmm. Just
And you're
like
no
that.
longer
All better.
entitled to that 10%.
Hmm.
So if you can take medication and that makes it better, you're no longer entitled to compensation. You're rated as if. Well, that's not really how that works. If you have to put a chemical into your body
Right.
in order to make you whole again, that doesn't mean you're whole. You shouldn't have to be changing the chemical orientation of your body in order to then, and then not receive some sort of compensation. There are side effects with that. You change your lifestyle, you can't do certain things, sometimes you can't eat certain way, you can't, I mean, there's just a whole sort of list of complementary hellish things that come with that.
Yeah.
And I just never thought I would see the day where that became, yeah, all right, But sure enough, it came, and there was a fast and furious response.
And part of that fast and furious response was in the weeds of administrative law, but they're important weeds because of course the US Department of Veterans Affairs is an agency of the executive branch of the federal government. That means they are subject, like is every other agency in the executive branch, pretty much, to the terms and conditions of the Administrative Procedure Act. And there are requirements for such things as a public notice and comment to give veterans advocates the chance to say, not on our watch, like they ultimately wound up saying. And one of the most concerning things, I think, from a legalistic perspective, beyond what the VA was doing and the adverse impacts of it upon veterans and members of their families, by saying, oh, the ameliorative effects of medication are now all of a sudden going to be used to give you a lower disability compensation rating if you are a new claimant for a physical or mental health condition, was the VA's attempt to, in my opinion, run an end around the Administrative Procedure Act by saying this is now an interim final rule that we don't have to put out for notice and comment. We don't have to go through all of those hoops. That just wastes too much time with that pesky law. So we're going to have an interim final rule and say, going forward, this shall be the standard until someone says otherwise. And what that would have done if that had stood is it would have essentially eviscerated a decade and a half, at minimum, arguably more, of federal case law from the United States Court of Appeals for Veterans Claims that specifically said the VA shall not do the very thing that the VA came awfully close to doing. And to be clear, when we talk about the effects of medication, what the courts have said is okay, VA, if you want to consider the ameliorative effects of medication on the veteran when assigning them a rating, your obligation is to create a schedule of ratings for that condition that specifically says, oh, if you're taking meds and they're working, your rating can be lower than if you're not taking meds, or if you're taking meds and they aren't working. The classic example that we see is hypertension, right? Blood pressure medication, if it works, can be used to assign a lower disability compensation rating for a veteran who has service connected hypertension. That's why we see so many veterans out there with a 0% rating or a 10% rating for hypertension. Because the schedule of ratings itself, written by the VA, empowers the VA to do that. But what the courts have also said is VA, unless you specifically contemplate in your own schedule of ratings the effects of medication, you can't do it. You can't just all of a sudden say, oh, yeah, because you're taking this and your pain is not so bad, you drop from 50% to 10%. You can't do that. And the courts have been solid on that, like I said, for easily a decade and a half and arguably longer. And so, getting back to what concerned me from a legalistic perspective with this was the VA secretary saying, we don't have to follow notice and comment. We don't have to follow those administrative procedures because we've been doing it this way all along. This is just clarifying what we already do. If that statement is true, that means the VA has been violating federal court precedent for a decade and a half, which I hope they have not been doing. So to hear the top person in the VA say that really kind of knocked me for a loop. To hear them say, "Oh yeah, we've been doing it already. This just clarifies what we are already doing." Now, to their credit, the outcry worked, and to any veterans advocates who are listening to this, who are part of that outcry, thank you, because you showed what the unity of voices can do when united in a just cause. I think that's incredibly important. And the VA secretary did listen. Some could say, oh, he was forced to listen. Regardless, he listened. And he did, in fact, repeal the interim final rule. He then took it off the Federal Register entirely. And in front of gatherings of advocates in recent about three to 4 weeks now, has been saying, we went there once, we're not going back there again. I hope that's correct. I hope that VA's leadership kind of saw the error of their ways and now recognizes, hey, don't mess around with the earned benefits of the people who served this country in military uniform. That's not what you're put here to do. That's not what the VA's mission is, and Congress has been clear that that is not what the VA's mission is, going all the way back to the end of the Civil War, when the precursor of the modern day VA really came into being. So we shall see, right? I'm cautiously optimistic that the current VA leadership learned their lesson from that caper, but we'll see what comes
If
next.
I would have been fine with him taking the advice and needing that, because that's
Right.
part of what
Yeah.
our system is. It's
Yeah.
just that it wasn't just that. It
It
was
wasn't
the
just that.
additional step of we needed to then go and file for injunctive relief. And
Correct.
that is what
Yeah.
had to happen before. So it wasn't just you took the advice and you listened to what we had to say. We had to file for injunctive relief. And so quite it wasn't quite as much as, okay, I heard
Yeah.
everybody is filing comments. I mean, we broke records in terms of how much happened in a 24, 48,
Hmm.
72 hour period. It had to go one step further. And that
Right.
was where there's a tone deafness there that
Yeah, I
I'm
agree with
I'm
that.
having
Yeah.
a problem with.
Hmm. Yeah. I mean, and let's not forget the reason why we got to this point in the first place is that people couldn't file a traditional comment for the longest time because the secretary tried to circumvent the notice and comment process.
Right,
And I
right.
hope we don't see that again, but subsequent to that, we've seen, for example, the secretary of the VA enter into what appears to be some kind of a agreement with the Department of Justice to do some things that they have not done before either. And again, this did not go out for notice and comment either. It's not being pitched as traditional rulemaking. Administrative law experts could argue, I'm sure, back and forth: should it be, should it not be? But again, we're seeing a lot of movement outside of what I would largely call the traditional process of how agencies put forth, or at least in a perfect world, are supposed to put forth policies for implementation. And sometimes leaping before they look, in my estimation.
As you said, there are different ways to go about doing things. If you don't like a law, then there's a different way to go about doing it, but you don't just go willy nilly and do whatever the heck you want with it. I have heard multiple times the secretary speak. I think he's a phenomenal
Absolutely.
speaker. I think he is wonderful. He lights the room up.
Hmm.
But what I've also noticed is time after time, he's lost the room. Um, he people have not, and I don't. That when I say tone deaf, I don't know that he knows he's lost the room because I think he is listening to himself. His people are listening to him, listen to himself, and they're focused on what they think, what they want to hear, what they think is best for the veterans and for the military community that are going to become veterans. And that's what's happening within the agency. Now,
Hmm.
I've been told lately that, and this we can talk about, the entire reason I started this podcast, the entire reason I started Gen Vets was to bring the veterans to the table, to bring VA to the table, whether it's state, local, to bring nonprofits to the table, because stop complaining.
Yeah.
Come and let's talk,
Yeah.
because I think VA
As
is
a group.
wonderful
Hmm.
as a group. I'm not going to be the one who says VA sucks. And because if you are going to be part of the solution, you need to be part of the people that are bringing everything out and talk about it in the open.
Hmm.
I know too many people who work there that are working their asses off every day.
Absolutely.
And I'm
Yeah.
not going to be, it's just, you can't just make this general statement that, they do nothing. They're out there and it's just, they're lazy. No, they're not.
No.
What I will say, and what I've said time and time again, and it has gotten significantly worse. Do not talk to me about a claims backlog
Yeah.
being reduced unless you're
Yes.
going to acknowledge what the appeals backlog now is. I've been told, don't complain. Stop complaining. No, that's not going to do you any good. Jen, as an advocate, as a leader of a nonprofit, if all you're going to do is complain about VA, your time is wasted, and that's no good. That's just like everybody else. And in more than one circle, I let you don't know me. You don't know what I do. If you think all I'm doing is
Right.
complaining,
Yeah.
I don't know what to tell you. I mean, it's not the time or place for me to get into a different discussion about it. If I don't complain in your words, if I don't speak out, if I don't register my feelings on it, what is it that we're doing? Is it because I'm speaking out against a big giant conglomerate piece of the government that's a waste of my time because it's too big? Well, I'm sorry. I don't buy that. I don't buy into that because I'm part of the process. That's what
Hmm.
this democracy is. That's what I was taught in school. And if I sound like a dork for saying it, okay.
Well, I'm right there with you then, so we can be dorks together, I guess. I have the same opinion. I mean, I and we saw this, right? We saw this with the interim final rule, where people spoke up, and that forced the VA leadership to back down and say, "Okay, we're not going to do this. We're not going to hold it against a veteran when they take medication that helps them for a service-connected condition." And I agree with you too about the issue with accuracy and the appeals backlog. And one of the most astounding things that I heard at that gathering in Arlington, where we were both together, was the principal undersecretary for benefits briefing the group and stating that we're processing claims faster than ever. True, no issue there. And,
Mhm.
speed can be good, not always,
Yeah,
but it can be good. But then she went on to say, and we don't want to hear that it's causing a decline in accuracy. We have an accuracy rate that's above 90%. And I nearly fell off my chair.
93.4%.
Right.
93.4%.
Yeah. I'm not seeing that. I don't think you're seeing that
I'd
either.
like to know what the metrics
And I
are.
have yet to meet a veterans advocate who is seeing that.
No, it's been discussed wildly. It's the Nova um, conference. That what is 93.4%?
Right. What does that signify?
Who is claiming 93.4% in most areas of anything? I mean, that's a very, very bold statement for anyone to make, much less this organization. And all it does is like make everyone's hair stand up
Yeah.
because show me the money. I
Right.
mean, what?
Exactly. Quite literally. Yes.
Quite literally is right because I don't think anyone is seeing it.
No. No.
And we don't and the circuit, I believe you asked a follow-up question somewhere along in that, and where are you in that? Tell us what you asked. Tell us the answer you got was an email address. Have you followed up on that?
Yeah, I have, and there has not been much in the way of answers. I mean, the obvious question when someone reports a statistic is where does this number come from? If we're saying you have an accuracy rate in your claims adjudication of 93% and change,
Mhm.
where is that coming from? Who is measuring that? How is it being measured? Right, and what is being done to really evaluate that? And there's so many different possibilities of how that statistical data point could be reached. We could be here for another hour easily discussing just that topic and speculating how they reached that number. The bottom line, though, as far as I'm concerned, is that is not what veterans advocates or veterans themselves should have to do. This is an agency of the U.S. government that is paid for by taxpayer dollars. The people themselves have a right to know when they're quoting a number where that number comes from, and they have a right to also know why that number seems to make no sense to anyone in the veterans advocacy space. We have an appellate unit here in New York State that brings cases before the Board of Veterans Appeals, and we have an extremely high success rate. That means that in each of those cases, the Veterans Benefits Administration got the law wrong, or they got the facts wrong, or they got both things wrong. Uh, so if this is just one state in the union that has that high of a success rate in our appellate advocacy, I don't think we're that much of an outlier. That means other states also are pursuing appellate action and winning cases because VA is getting stuff wrong. And one of my big pushes, and I'll throw it out here for anyone on the podcast audience who wants to hear it, is that once upon a time, at least in the veterans service officers world, there was the ability to see a decision 48 hours before it was rendered final and sent to the claimant. And that was taken away by the Veterans Benefits Administration under the analysis of, oh, we have to get the decisions out to veterans faster. We don't want veterans having to wait for their money. And again, I'd be happy to conduct a nationwide survey on this one. I doubt I would find a single veteran who says, oh, I'd love to have a decision 48 hours faster. That is entirely wrong, as opposed to waiting 48 hours more and giving my advocate, to whom I've given power of attorney, the opportunity to converse with VA and point out obvious errors of fact or obvious errors of law that can lead to a correct decision being issued from the outset. And that's going to winnow down that appeals backlog that you were talking about, because more good decisions up front leads to a reduction of that backlog for the higher level reviews, for the supplemental claims, and for the Board of Veterans Appeals cases. And VA has been resistant. And I have brought this up year after year
Well,
after
that
year.
slows down the speed.
That's
That would
right.
slow down the
Much
speed of
longer
the
wait
claims
if you
process.
have to appeal than if you take 48 hours, give the advocate a chance to review, and point out obvious errors of fact or law. Now, VA, their most recent response on this has been, well, we have a pilot program going on now, which they do, which allows veterans to have that chance to address obvious errors of fact or law. That is also true. The problem is that the devil is in the details. And the details tell us that there are many different types of claims that are not part of that pilot program. The VA has said that these types of claims are just not going to be considered. Okay? And I find that to be extremely concerning. For example, Blue Water Navy veteran claims. And let's be honest, the VA has not liked Blue Water Navy veteran cases from the beginning. The notion that Agent Orange could extend 12 nautical miles offshore in the Republic of Vietnam, they've opposed that from the outset, back in the days when Paul Lawrence was the Undersecretary for Benefits. They said, we don't believe in this. I guess their belief was Agent Orange came to the shoreline and just stopped. I mean, I can't figure that science out, but that was the belief, apparently. And so they've been really kind of resistant to this from the beginning. Now, in this particular pilot program, Blue Water Navy claims are not included. NEMR claims involving veterans who were exposed to Agent Orange in Vietnam, who now, years later, are saying, hey, you denied my claim for type 2 diabetes in 1994. And now that that's a presumptive condition, I'm reopening this and I want to be paid all the way back to my original date of claim. What's happening there is, if the VA gets any part of that wrong, to include the calculation of the effective date, which they constantly are getting wrong in NEMR cases, those are not part of the pilot program either. So you can see where I'm going with this. The exceptions wind up
Yeah,
almost
yeah.
swallowing the whole, as opposed to just saying, advocates, 48 hours before we send this decision to your client, it's going to be online through our secure web enabled case management software. You'll get a notice. Go on there, look it over. You have 48 hours to give us a response to say, we see some error that's obvious, a fact or law. We want to have a second look at this, a second review at this. I don't see how that slows down the works any more than making the veteran get a grossly erroneous decision, which they then have to appeal through one of the three lanes, which then slows down that process far more, encumbers that area of the VA workforce all the more. It just makes no sense. But VA has stuck to that position now
When
for
did the
years.
pilot program start?
The pilot program has been brought in various phases. We're right now in phase four. So, for example, for a long time, Camp Lejeune cases were not included, and ionizing radiation disability compensation cases are not included either. Those were added on in phase four, which was effective October 1st of 2024. Um, but how long do we have to have this be a multi-phase pilot program before it turns into a real program?
Yeah,
And
yeah.
VA has no answer for that. Again, I asked the principal deputy undersecretary for benefits that question, and she and her assistant took my business card, promised me a response, and thus far, I still have not received that response. Go figure. And I'm not exactly holding my breath to get it either. But it does beg the question: at what point does this pilot program finally stop being a thing that we're testing out and turn into a real thing that we do in what is supposedly a proclaimant, non-adversarial system to give the best possible advantage to the veterans and their advocates who are preparing, presenting, and prosecuting these claims. And VA does not seem to want to answer that question.
The other part, the other component of this is that when you have this system where we have the backlog, we have, well, there was once, as you know, an enormous backlog of appeals. So,
And there still is.
yes, so there's a pendulum, right? But it was once like all the way up here. It's come down, and now you have the claims that had, because of the PACT Act and all of that, we have so many more claims, and then now those are coming down. But I honestly, we don't hear as much about the mid level of appeals, because there's also AMA, and there's so many different pots of appeals. We don't know what's where when, and that's also very interesting. Today I received word that I have a hearing for higher level review. Those hearings used to be taking place in a week or two.
The informal conferences, right?
Right.
Yeah,
Which
yeah.
I'm not even necessarily think that it's worth that anymore, because I've had things where it is literally the law is here, this was the mistake, and I'm denied the next day. I
Mhm.
don't know, that's a waste of time. And it's not up for interpretation. It's not. So a mistake was made here. This is what this is supposed to be. I can't, and then there's nothing you can do in the intermediary. Are you to go back for a supplemental claim with what? With
Right.
what?
Yeah.
I mean,
Where's your new and relevant evidence? And this is a really important point, right? Because that creates a catch-22 situation for the veteran and for their advocates. I had a Section 1151 claim that dragged on for years before it finally got resolved in the veteran's favor, I'm thankful to say, but it took years to get there. And part of why it took years was the VA was bandying back and forth between, well, is the proper vehicle here a higher level review or is it a supplemental claim? And whichever side I was going with was saying it was the other. And one of the unique things, I'll use that word because other words are not good words. One of the unique things about how VA treats higher level reviews is they say that if you add a novel legal argument, in other words, something that was not
correct.
in the original claim package, into the case, that no longer should be a higher. It could be all the same evidence, right? All the same stuff,
Mhm.
all the same documents. But once you add that novel legal argument, that now goes outside of the realm of the snapshot of the original case that the higher level review is supposed to be. And so VA's perspective on that is, well, now that has to be
Wait,
a supplemental claim. The
what?
problem is they haven't exactly given that memo, it seems, to the people who adjudicate these supplemental claims because they're saying, well, there's no new evidence here. It can't be over in this lane. Put it back over there. And the folks over in the high level review lane are saying, well, no, it doesn't belong here. It goes over there. And they ping pong things back and forth without getting to the actual merits of the case, which again
And
brings
what are
me
your
back
thoughts
to
on that?
proclaimant non adversarial system. Is that really taking
Yes.
place? when debates are raging sometimes for years about matters of procedure that are not clearly articulated in the governing laws and regulations surrounding this process. So my thought with that is two things. Either number one, VA do the common sense thing and allow someone to raise a new legal argument that they might not have raised in the original case because, oh, by the way, they didn't think it was a needed argument until you denied the case with some creative rationale to begin with. Or two, put out actual regulations that everyone can see clearly stating that a novel legal argument cannot be raised in the higher level review lane and define what exactly that means. Because right now it seems to mean different things to different people within the Veterans Benefits Administration structure. And that's not how it's supposed to be. The whole legal system is not supposed to be a guessing game.
They did. So you get a decision. There was no argument. They didn't do anything.
Right,
That's when you go to a higher level review.
right.
How can you There was nothing raised originally.
See, and that's where it becomes confusing because VA will
Mhm.
say in such cases that if you send in essentially a snapshot of the original claim and say basically, VA, you got this one wrong, take a second look, that's fine for a higher level review. However, if you say, VA, you got this wrong because you failed to apply the principles of the sharp precedent as it pertains to orthopedic flare ups, that can be
Right.
seen as a novel legal argument, and VA then possesses the ability to kick that back and say, sorry, this is not the right lane, try again, which causes further delay in the case, further angst for the veteran who is waiting to get justice in the case, and leaves advocates totally confused about what is or is not a higher level review.
That smacks in the
Yeah.
face of what I understand a higher level review to be. That's what I do with higher level reviews
Hmm.
because these are supposed to be decision review officers, like the equivalent of what used to be these with these 20 years of experience, and it is something where the lower level raters misapplied or didn't understand a legal principle, the
Right.
law, and you go to them and you explain under Sharp, under Gilbert, this is something that didn't happen. So if that's not what that lane is for, what are we doing?
And there seems to be confusion on that point. And the confusion, with all due respect to the VA, is coming within the VA.
That's what I was just going to say.
Because I've seen different VA adjudicators treat this differently. And that's not helpful.
This is a self-licking ice cream cone. Yeah, well, I see you're bringing up things I didn't even know existed. I've been doing it that way. But you know what? I'm still waiting for decisions on my higher level review conferences for a year and a half ago. So I wouldn't know one way or the other whether or not some of what you're talking about. So therefore, I'm now I'm now continuing to operate under one theory of how we practice, and I won't know if that's wrong or not for another year and a half
Right.
because
Till it comes back with a decision.
this is really unfortunate.
And it's gotten to the point now where if I present that kind of a case, I will actually write in paragraph one of my narrative, there is no new evidence being presented in this matter, just to spell it out for whatever person or whatever machine, because we know we're seeing the introduction now of artificial intelligence
Yep,
into the adjudicatory process. Whatever they're looking, they can find those keywords front and center unambiguously. Is that helping? I'm
that's
not
good
sure,
advice.
but I'm at least making the attempt by putting it right there front and center
That's
for them to hopefully see and comprehend.
that's really good advice. I hadn't thought about that, but that's really good advice. There's no new and relevant evidence here because no, I hadn't thought of that. The other part I keep going back to that was raised is I have made the statement I don't think that I am wrong, but unfortunately, there is no study. I would like one to be made. I have a couple sources that I'd like to go to and suggest. I'm sure this is underway. The correlation between these sorts of things, these denials, the delays, the interactions, the frustrations, the canceled medical exams, the distance, all of these, the caretaker issues, um, and mental health within VA, with the
Oh, yes.
suicide numbers. I was told, don't you dare make a statement like that. Be very careful. Okay, fair enough. There is not anything definitive. But don't you dare tell me there isn't a correlation.
I agree 1,000%.
I've been working within this population. Don't sit back and say there isn't either. I'm not washing everything on VA or VA benefits. My God, everybody is helping and working and doing the same thing. But don't pretend that, and I shouldn't say pretend. Don't say your number one priority is suicide and mental health, and then look at the face of what's going on, what we're all screaming and helping. Devote your time, energy, and effort into fixing what is broken here, and fixing and helping this problem, if that is truly what is. Because, so going back to my point at this conference this day, that is to take away the victim mentality that a lot of these veterans who are seeking 100% compensation, who cannot, that are so focused on, I got to get 100%, I got to get 100%, my buddy's at 100%, everybody's at 100%. You are, that is true, that exists. I'm not, there is fraud, there is all of that, but there's also a population of people within these veterans who are so angry and so then become focused on, I am not going to get screwed one more time. They
Yeah,
become laser focused on winning because they are not going to be, because of what's happened, how they've been lied to, how it becomes this vicious cycle that when they wake up every morning, it is what they're going to do, how they're going to get there, how they're, because this is not going to happen to them again. That's where the mental health component of that comes in here, where I think we need to look at, and I don't think it's being addressed or taken seriously. That
quite
that's
recently.
just, Jen, I don't, yeah.
No, it's my opinion as well. I share that belief with you 1,000%. Quite recently, the Veterans Health Administration released their most recent suicide report, looking in some depth at the tragedy of the number of veterans who died by suicide during 2023. It's the most recent year where full data is
Mhm.
available, and they analyzed that data in many different demographic groups, age groups, and so on. But you know one data point they don't have in that report? How many of those veterans had been denied at least once at the time of their death by suicide, erroneously, by the Veterans Benefits Administration for disability compensation, pension, or whatever, or by the Veterans Health Administration for access to the care that they were trying to get, because that's a bureaucracy too. And I don't mean to say bureaucracy in the sense of all bureaucracies are bad. Some bureaucracies are high functioning. This one does not
Mhm.
seem to be. I'll give you one example of that, and I'll try and keep it as brief as I can. There's a statute, Title 38, Section 1720I. It's known as the Honor Our Commitment Act.
Mhm.
It's been around for quite a long time. And what it says is that if you are a combat veteran or if you are a survivor of military sexual trauma and you present at a VA healthcare facility and you are seeking mental health care or behavioral health care, you can get that care as long as you were not discharged by a military court martial. And as recently as last week, I was grappling with an issue with a veteran who was suicidal in the western part of New York State, who was being denied access to that care that he needed. He knew he needed. He self referred to a VA facility. And the VA facility was telling him, sorry, the gates are closed because you have an other than honorable discharge. Well, by definition, that classification of discharge cannot be issued by court martial. It's an administrative separation. So here we have, to your point, the VA leadership saying our number one priority is to prevent veteran suicide. Great. I agree with that priority. But then that same agency has people serving as gatekeepers, in this context, in the healthcare space, who are denying care illegally to a veteran who is fully eligible for such care and who is in the greatest need of such care. When we look at combat veterans and veterans who are survivors of military sexual trauma, we're looking at two subsets of the veteran population who logically are at heightened risk of death by suicide. Again, not uniformly, not one size fits all, not across the board, but as a generality, one can reasonably presume these would be subsets of that veteran population who would be at heightened risk of suicide. And that's why we have laws on the books like the Honor Our Commitment Act to address those needs and to get them to care, even if they don't have the word honorable printed on their DD 214. And yet here we have the VA itself keeping a veteran who fit those standards to a T out of healthcare and would have kept on doing so had our agency not intervened on the veteran's behalf. And each time I do this, each time my colleagues do this, each time we manage to intervene successfully, the question that burns into my mind is how many are we missing? Who is that veteran who went to get health care, right, or who went to get their benefits and are eligible for them and are being told no, that we're not finding? And how is that answer of no impacting adversely their mental health, their well being? And I agree. One of the things that drives me nuts is when someone in the VA or any place else says, "Oh, you're really passionate about this, but stand down. We're taking care of it." It drives me up a wall, just like you said, it drives you up a wall, because at the end of the day, there is a history and tradition in this nation of individuals in seats of power telling members of the populace, "Oh, you're really passionate, but stand down. We've got this." And if everyone had listened to that, there would have been no civil rights movement. There would have been no labor movement. There would have been no women's suffrage movement. The list goes on and on. And so even today in 2026, when people are saying, "Oh, you're really passionate, but stand down, we've got this under control," that makes me pretty darn nervous because that's often a cue for just be quiet. Some right or some law is about to be abridged, and we don't want you to say anything about it. And I feel very adamantly that anytime we hear that, we as advocates have a calling to raise up our spidey sense and say, okay, that's now more fuel for the fire to keep pushing for this. Because if you're saying that, there's probably something going on that you don't want us to be knowing about. And now we're going to look just a little bit harder to find it and to advocate for right to be done. So I'm right there with you on the impact of those types of statements.
I just so love these with you. And anyone who's listening, please feel free to email us. We'll put our email addresses up,
Absolutely.
and let us know if there's anything you'd like to have us go on and on and on about. Um, because Benjamin can talk as much as I can, and I like hearing him talk too. It's wonderful. Thank you.
And likewise, and the last podcast that we had together, I have a good news story to wrap up with, which is that there was a veteran from the southern part of New York, around the Pennsylvania border, southwestern part of the state, who heard this, and we were talking about certain issues in appellate advocacy, and she reached out to me, and our agency represented her in some appellate advocacy that needed to be done that was long overdue, and we were able to get a victory for her compensation claim with full retroactive benefits.
That makes me so happy.
I was saving that story to tell you until the end, but that is the impact of what this can do when people get together to say, here's what needs to be done. and she heard some things in the dialogue that resonated with her about her case. That's how it began, and it ended with a successful outcome before the VA in one of those appellate lanes that we were just talking about.
Thank you for telling me that, and thank you for saving it for the end. I have a big meeting I have to go to, and I just really needed that. So thank you.
Excellent. Well, thank you.
Well, all right. Okay. So until next time, I need a closing. I need something like until next time, unvetted. I appreciate you, and we'll talk soon. And it won't be that long until we talk again, but yeah. All right. Thank you for everything you bring and everything you share with the members of this audience and beyond. You really are one of the I tell everybody you're the smartest veterans advocate that I know, a veterans lawyer. So I do. I really think that you are quite brilliant. So
Well, you're very kind. Thank you very much.
I always say Linda Blauett is up. She's my mentor from way back when, and she is who she is. But you're right there. So she came first. Sorry.
Well, thank you for the work that you do. Thank you for the advocacy that propelled so much of this forward. And as always, to anyone in the audience here who is listening who has served in the military, thank you for your service. And anyone in a military family, military spouses, military
Right.
children, month of the military child in April, I have my purple on even today. Thank you for your service as well. It is remembered, it is never forgotten, and we are here to advocate for you.
That's right. All right, Benjamin. Have a good one. Thank you. Take
Thank
care.
you.